ask you a question, I want to rephrase it a little bit to focus your answer. I asked you whether or not the firing of a single shot evidenced certain ill will or hatred. I want to clarify that a little bit and then just ask you to answer it yes or no, so we get to that point, but I don't want you to expound too much on that, okay? The modification of my question is this. Looking at the fact that the gun was fired at close range, did you know what premise question you're on? Did you know the gun, did you know how far away approximately the gun was from Mr. Martin when it was fired?
Yes.
And what did you know that to be approximately?
If I remember reading correctly, it was within 6 inches.
Okay. Realizing that as a premise question, that it was a close range shot and that it was shot one time, did that evidence to you, based upon your training and experience, anything that would suggest ill will, spite, or hatred towards Mr. Martin by Mr. Zimmerman?
No.
Now, let's go to the point after the shot is fired. In your background and training and experience of people involved in shootings, how are, as an example, how are law enforcement shootings handled as far as the interview of the person who shot?
Well, generally speaking, with law enforcement involved shootings, it's they do a...
Objection, Your Honor. I'm going to object to relevance.
I can respond, I just don't want to speak.
Well, and I think if it's to put it into context, I'll give you some leeway.
Thank you. And just so we're clear as to that, the majority of your experience and training is because of your law enforcement background. You deal with law enforcement events, correct?
Yes.
Have you had experience where you handled non-law enforcement shooting events?
Yes.
Okay. So do you have an experience level that covers both law enforcement and non-law enforcement shootings?
Yes.
Is the majority of yours, however, in law enforcement shootings?
Yes.
By nature of you being a cop?
And yes, I'm just retired a couple of years ago.
Okay. With realizing that, using the complete broad base of your experience, including law enforcement shootings and non-law enforcement shootings, what are the concerns that exist with interviewing a person who's been involved in the event of a shooting?
Memory issues. Generally speaking, the primary concern is people, when they're involved in a high-stress event, can have what they call critical stress amnesia, or they can have temporary memory holes, I call them, that sometimes it takes up to 72 hours before they truly get their full memory back about everything that took place. And for some, depending on the stress of the event, they may never remember everything that took place.
What are the concerns then with interviewing those people within that time period from a law enforcement perspective?
Well, the concerns, I think, whether it's law enforcement or anything, your primary concerns with conducting the interviews is how accurate the information is going to be. Has the person been able to reconcile and compartmentalize the event itself and start to accept what has taken place so that they can come forward with all the information? And then there's always the problem also that if I use myself as a reference, if I was involved in a shooting and I gave you a statement, an hour later, and then tomorrow I remember something a little bit differently because my memory is evolving and I'm starting to work through my own personal conflicts, whatever the case might be, I can have a varied statement now. And if too much weight is given, depending on the variation, I'm not talking about a completely different change in statements. I'm talking about slight changes or modifications. If too much weight is given to a change, now the person's expected that, well, now I'm lying. And the reality is it may take me some time to form everything back to be able to provide you with an accurate reflection of what took place.
Are there procedures that are in place to safeguard against those concerns with law enforcement officers shooting investigations?
Object as to relevance, Your Honor.
I'll rephrase it, just so we're clear. In all of your experience, both law enforcement involved shootings and non-law enforcement involved shootings, are there policies or best practices that you're aware of as to any delay period or time concerns about interviewing shooters?
Best practice. You want me to tell you what the best practices
Yes.
are? My experiences have been is any kind of delay. You get just a generalized statement at the beginning, an overview statement, nothing in depth, and then you wait. And generally speaking, in a law enforcement world, you have attorneys and PBA reps that immediately come in. That's just the general practice, that they come in and are present during any subsequent statement.
Close to being done. I was going to ask for a few minutes. Didn't know if this was a good time for a morning break.
Do you need a break? Ladies and gentlemen? They're good.
Okay, then I'm still going to ask for a minute, if I might.
Yes, ma'am.
Mike, Your Honor, there was another area of inquiry that I didn't go into just for a moment, and that would be specific to your firearms training. It was a while ago, but I think we've gotten the concept that you are fairly well trained in all areas of weapon systems, including firearms.
Yes, sir.
Do you actually teach other people how to handle and utilize firearms?
Yes, I conduct individual trainings for everything from basic handgun fundamentals through intermediate, advanced, and tactical application of handgun.
Do you have an opportunity to identify the type of gun that was used in this case?
Yes.
The Kel-Tec 9?
Yes, sir.
Okay. Can you explain for the jury, based upon your training and experience, the appropriateness for use as a self-defense weapon, or the lack of appropriateness as that gun as a self-defense weapon?
Any firearms, if the individual is willing to carry a firearm for self-protection and willing to do so in accordance, with all the training and backgrounds that should go with it, any firearm is a good selection. It's a matter of selecting the weapon system that's good for you. When it comes to that particular weapon, it's a 9mm. It offers some advantages, some disadvantages, and it all depends on the individual, because it's a very personal selection when it comes to selecting a firearm for choice as far as self-defense.
I'd like you to focus on the safety. We have it available, but do you have enough of a working knowledge of the gun to be able to talk about it without seeing it?
Yes.
Okay. And if I might have a little bit of leeway to lead you, it is a weapon that doesn't have an external hammer?
Correct.
And no external safeties, correct?
Correct.
Then do you believe that gun to be a safe weapon to carry?
Of course.
And why? Tell the jury, if you would, what safety, why is it safe, or how do you carry it in a safe way?
The most important safety of every single firearm is the person holding it. Because the reality of the modern day manufactured firearm is the only way that the firearm is going to discharge is if you squeeze the trigger all the way to the rear. A lot of people make assumptions based on, because like the Berettas and things like that, there are various Smith & Wessons, there's various products available that have external safeties. In other words, you flip the safety to the down position, gun will not function at all. The downside to that, when you consider a firearm for personal safety, is under high-stress events, your brain's not going to remember, without a tremendous amount of constant and ongoing training, your brain's not going to remember that you have to flip the safety up before you can utilize the firearm. Because under stress, you're going to do what you did at the range. You're going to discharge it. So having those external safeties, as a safety person myself, they actually create a problem. This particular weapon being double action only, equivalent of double action only, there's no hammer to come back and go forward, but the trigger pull of 5 pounds or greater means that you have to intentionally put your finger on the trigger to press it all the way to the rear. And it has an internal safety, it has a hammer block safety, and the only way to defeat a hammer block safety on any firearm is to press and hold the trigger all the way to the rear. So in and of themselves, a lot of people misconstrue that because there's no external safety, it's not a safe firearm. And that's not accurate. A firearm is as safe as the person holding it. So as long as you're not putting your finger on the trigger and squeezing it, it can be a safe weapon. There's a variety of weapons that are manufactured. This particular weapon does have an internal safety, which is a hammer block safety, but it also has, at least from my understanding, now I have not examined this particular firearm, but the Kel-Tec, I believe it's the PF9, has got like a 5-pound trigger, which is a good standard trigger pull because it makes it hard enough not to just get hung up on clothing, but not so hard that you have to have super grip to be able to discharge the firearm.
If there was testimony and evidence from firearm experts that the trigger pull was 4.5 to 4 3/4 pounds, is that in the range of what you're talking about, which is a safe range?
Yes, sir. Without taking it to gun manufacturers, I mean, if you look at the manufacturers, they say it comes with a specific 5-pound trigger. How they're achieving their numbers versus how somebody else is measuring it, that's beyond my scope for that.
There's testimony concerning an internal holster for a concealed weapon. Is that in any way an unsafe way to handle or to carry a weapon?
Carrying an internal, the idea behind a concealed weapons permit is you have to keep it concealed. Anytime you take a weapon and put it on the outside of your belt line, that's something a shirt has to cover, a jacket has to cover, and it makes it more difficult. So the most common things that you can find are in what we call in-pant holsters, where they slide inside the pants themselves, inside the belt line. Some hook around the belt, some have a clip that hook right onto the pants. The idea is it makes it easier to conceal so that you don't have to have a jacket. You could do it with just a pullover shirt or something to that effect. And it doesn't make it an unsafe holster or anything like that. It's a preference issue.
If in your firearm training, when you train both officers and non-officers, is it safe or unsafe to have a round chamber, I guess is the word, you use your word. Is that the way you should or should not have a gun?
This is like one of those debates from old. Having a round in the chamber means you can discharge the firearm immediately. Not having a round in the chamber means that in a high-stress event, you need to remember to work the action on the slide. In other words, pull the slide all the way to the rear, let it go, so that it will feed a round. We go right back to the concept of why you don't have external safeties on a firearm. Under stress, under any type of actual threat, you may not have the time to work it, and more importantly, you may not have the memory that, I've got to load one into the round, or a round into the chamber. Carrying it full, magazine full, and one in the chamber is the best way to carry a firearm. Because if you're carrying it for self-defense, if you're carrying it for self-protection, you might as well, you have the equivalent of an unloaded weapon when you have a weapon that hasn't been quote-unquote charged. When you take a magazine and stick it inside a firearm, people will tell you, well, you've loaded the gun. That's not exactly completely accurate. You have loaded the magazine and placed it in the weapon, but you have not charged it. Therefore, the weapon is not actually loaded, because loaded would indicate that you could pull the trigger and something would happen. If you don't have one in the chamber, you pull the trigger. If the hammer is cocked, or if it's a Glock or whatever, and it's allowed to fall forward, it's falling on empty space, so now you have to work the action of the weapon to get it to work. Carrying it without a round in the chamber, why carry it?
And you mentioned a moment ago, one in the chamber and a full magazine. Is it appropriate or inappropriate to load it in the chamber and then put the additional bullet that's now been taken out of the magazine back into the magazine so you have a full magazine?
Again, my training and all my experience and what I train people to do is, if you're carrying a firearm and it will hold 7 rounds in a magazine and 1 in the chamber, or hold 15 in the magazine and 1, whatever it will do, load the chamber and make sure the magazine is fully loaded so that you have the full complement of ammunition that weapon is designed to carry.
In evidence are the bullets themselves that were in the gun, which are hollow point bullets. Do you have experience with those?
I have experience with the ammunition. I'm not a ballistics expert.
No. I'm just curious, is the hollow point bullet an appropriate self-defense bullet to carry, to utilize?
Yes. The reason being, when you look at a round-nosed bullet or something like that, it's kind of like what you see in the movies all the time with the big point at the top of the bullet. The problem with that is there's a really good chance it won't, what we call mushroom. When a bullet impacts soft tissue, its design is to widen out to create a better wound channel, but the more important thing is it stops inside the soft tissues. Sometimes it exits, sometimes it doesn't. But the idea behind a hollow point is that there's this center cavity that when it hits, helps it widen out, which means it's less likely to over-penetrate. It's less likely to exit a person. Whereas a round-nosed round or a wad cutter or the variety of other ammunitions, because they're solid-nosed, when they hit, depending on how close they are, they can still, the energy is still going, it hasn't mushroomed enough, and it may actually exit, which means as a self-defense weapon, your goal is just to deal, hopefully, with one person, and otherwise, with the wrong ammunition, it can go through, and now you've got to worry about your background being struck by the round that you fired.
So in a very strange way is the use of a hollow point bullet, though it will cause injury to the first person it hits, less likely to cause injury to somebody behind the initial target.
Yes, because it's less likely to exit the first person that it impacts.
Thank you very much, Your Honor. No further questions.
Thank you, Cross.
Thank you.
Mr. Root, good morning.
Morning, sir.
Did I hear you to say that your opinion is because the defendant discharged his firearm a single time, that doesn't evidence to you ill will, hatred, spite, or evil intent?
Correct.
Okay. Did you have an opportunity to listen to the non-emergency call he made just moments before discharging his firearm?
Yes.
Did you hear him refer to the person he ended up shooting, Trayvon Martin, as an asshole?
I sure did, yes.
Did you hear him refer to Trayvon Martin as a fucking punk? Excuse my language.
Yes, I did.
Okay. And you realize that the defendant didn't know Trayvon Martin, right?
I do know that, yes.
Okay. So the terms fucking punk and asshole referring to a perfect stranger don't evidence to you any ill will, hatred, spite, or evil intent?
I think that people like to give a little bit too much weight, because if you look at it in the context in which it was stated, you know, his reference in that statement was addressing clearly addressing his frustrations from previous calls in which the individuals got away. His verbiage chosen may not be the most appropriate, but I don't necessarily mean that just because somebody has said that means that they mean ill will.
But the target of his frustration, you understand, was Trayvon Martin.
I would have to say that the comment, in my opinion, that frustration was being voiced at the fact that he's made numerous calls. The fact that he called, the other alternative is go, wow, these fellows always get away. I don't know what his general speech pattern is like in regards to how he refers to everybody else. So, in and of itself, I don't see that variable as showing ill will.
All right, well, let me ask you. You had a conversation with the defendant, did you not?
I did.
Did he call you a fucking punk during your conversation?
Not that I recall, no.
Did he call you an asshole?
Nope.
Did he use either one of those terms during your entire conversation?
Geared toward me? No, sir.
No, at all.
I don't recall if he was asked specifically about that.
No. In his conversation with you, did he say the word asshole?
I don't recall if at some point it came up during the conversations about that tape, but as far as the context being used to me, he did not call me that.
All right. And did I understand you to say that the most important factor about the safety of of any firearm is the responsibility of the user?
Sure.
So an irresponsible person can be really, really dangerous.
Absolutely. Any person that is reckless with their firearm can be dangerous, sure.
I want to talk for a moment about your connection with this case. You told the jury that you actually reached out to the defense, right?
Correct.
And tell the jury when you started your consulting company. That is what you're doing now.
I started doing consulting work at I want to say it was 2012, through Tactical Advantage Solutions. In 2013, I started Dennis Root & Associates, which is a private investigations and expert witness firm.
Dennis Root & Associates, you started earlier this year.
Yes, sir.
Okay. You understood when you contacted the defense in this case that this case was getting national, if not worldwide, attention.
Of course.
And you understood that there would be live coverage of this trial if you were to testify, right?
Yes, sir.
And assuming those cameras are working, you're on live television right now, right?
As far as I know, yes, sir.
And the name of your company is on live television, right?
I believe so, yes, sir.
So that's good for your company. You would agree with that, right?
I see where you're going. It's good for my company, but there wasn't really other options as far as approaching the state in the same way.
Well, didn't you think that you being a witness in this case might do your company some good? That is, you'd get your name out there?
There is no question that anybody that's seen anything about this case would be aware of the fact that it's getting media coverage. But anybody that does their homework about me knows the fact that I'm dedicated to finding the truth and supporting the truth. When I approached Mr. O'Mara about it, it's because I knew that the state would be able to gain access to somebody just like me with no issue. If I had approached the state about this, and let's say I determined whatever, that it wasn't going to be supportive for the state, or it would be, let's say for just instances that I found that I wouldn't be supportive, I now could not be in any way of assistance to the defense. However, if I reached out to the defense and I provided them with the opportunity and I found that, well, wait, I can't be any of assistance to you, I have not hindered the case in any way, and I could walk away without any problems and affecting in either way. So the fact that I gained some kind of media coverage from it isn't my fault, because those of us that are dedicated to the truth, those cameras are here. That's not why I'm here.
And isn't it true you've advertised the very fact that you are a witness in this case?
Yes, sir.
You've tweeted that out, right?
Tweeted? I haven't tweeted it.
How did you advertise it?
When I was put on the case, every attorney that I know knew about it. Obviously, in the fields that I go in, the attorneys, just like every other profession, talk. And then just this morning, I texted my friends to let them know that I would be testifying here today.
And in fact, you haven't been paid yet, have you?
No, sir.
Your agreement is you may get paid, you may not, right?
That's correct, sir.
Okay, but that's not your normal practice, right?
Actually, sir, it depending on the case that comes through, and if you looked at my background, you would know that I've done some things for free. I've done some things for some people for $20 an hour, and I've gotten paid up to $175 an hour. I really base it on the case that's presented to me.
Right, but didn't you provide me with an invoice sheet or the way that you bill clients?
For the expert witness, sir? Yes, sir.
Right.
Yes,
okay,
sir.
well, that's what you're doing here today, right?
Yes.
And it's $1,500 initially, and then $125 an hour after that?
Yes. The way it breaks down basically is if I'm hired in as an expert, my general fee schedule is there's a $1,500 deposit, and my hourly rate is $125 an hour. That is for case prep and review. Then on the dates that I testify, either by deposition or I testify in court, my hourly rate is $175 an hour, and that includes travel time and wait time.
And actually, you've never testified before a jury before, have you?
Excluding
in court like this?
You mean excluding grand juries?
Correct.
Yes, this is the first time that I've actually testified before a jury on a criminal case. In an expert capacity, I've testified obviously as an officer in a criminal case numerous times.
Right. You've testified against police officers, right?
Testified against police officers?
Yes, sir.
I have been presented with cases that I found that the officer was wrong. Yes, sir.
And you've testified to that?
That went through deposition, not in trial. Yes, sir.
I mean under oath.
Oh, yes, sir.
All right. But you've never testified in a case like this where one person, and I mean in court, where one person shoots another and the shooter is claiming self-defense?
No, this was the first time I was ever presented with something like this.
And you yourself have never been involved in a police shooting, have you?
I'm fortunate enough that, no, I've never had to shoot anyone.
In fact, you've never had to discharge your firearm in the course of your career, have you? I mean, other than at a range?
Right. Other than training sessions, scenario-based training, things like that, I've never had to discharge my firearm in the line of duty.
And you've never had to use any other type of deadly force in your career, have you?
Explain deadly force, sir. I mean, the things that I've had to do to people, I've caused injuries and things like that. And remember, deadly force just isn't about killing somebody. It's about causing serious bodily injury or death.
All right, but you've never caused someone else's death during the course of your career?
No, sir.
All right. And the first time you got information in this case would have been April of this year? A couple months ago?
Do you mean actual case stuff?
Yes, sir.
Oh, yes. Yes.
And one of the things you did was you interviewed the defendant.
I did have a conversation with him, yes, sir.
And the purpose was to get a first-hand account of what he remembers.
Yes, sir.
And you would agree with me, would you not, that as a person charged with murder, he would have a motive to fit the facts his way?
Sure. Anybody, if somebody was guilty of something they wanted to lie, you wouldn't lie to get yourself into trouble.
And you listened to the non-emergency call. I believe you testified to that, right?
Mr. Zimmerman's
Yes.
Yes, sir.
And you heard him describe Trayvon Martin in a couple of terms we've already talked about, but also as real suspicious, right?
Yes, sir.
And up to no good. You remember
Yes,
that?
sir. Yes,
You remember him telling the dispatcher that he's got his hands in his waistband.
I do recall that, yes, sir.
And he told the dispatcher he's got something in his hands. Right?
I believe he indicated that he thought he might have something. He wasn't sure. I don't believe he actually said he has something in his hands.
But you didn't ask the defendant, after making those observations, if he was concerned when he got out of his car.
Well, sir, just to proffer it, you say I didn't ask him anything. I don't think you were there,
No.
is what I'm trying to say.
Did you ask him that specific question? Were you concerned for your safety when you got out of the car?
No.
And I believe you'll recall in that phone call that he told the dispatcher that he went to the other side of the T. You're familiar with what I'm talking about. You've been to the scene.
Yes, sir.
That he went to the other side of the T to get a street address, a house address, right?
Told the dispatcher that?
Right.
I honestly don't recall.
Well, how about
that.
this? Did you watch the walkthrough?
Yes, sir.
Okay. Did he tell those people he went to get the thing?
Yes.
Address? Okay. But he never did tell the dispatcher a street address, did he?
No, sir. As the conversation was concluding, I believe that he just let it rest with have him meet him at his truck, and then it was have him call me and I'll tell him right where to meet me. Something to that effect.
And what was your understanding about the length of time from the defendant between the time he hung up with the dispatcher and the time that he claims he was confronted by Trayvon Martin?
It was not that great period of time.
Okay, but you were interested in that time because you've told us the timeline is important to you, right?
Oh, absolutely. But you have to understand that when we make inquiries, and you have to remember that Mr. Zimmerman's statements to me only account for a very small portion of weight that I give to my overall evaluation of the case. Because, just like the gentleman said, I can't base it all off somebody that may make self-serving statements. But the concept of time that everybody constantly gets hung up on is the fact that whether it's 15 seconds, 30 seconds, a minute, whatever the case might be, everybody's concept of time is different. So I don't make a huge deal out of what his perception of time would be for this given period.
But you would agree with me that the only person that you interviewed who had firsthand information from this event, from the start to the finish, was the defendant, right?
Yes, sir. He was the only one that I actually spoke to in person outside of Mr. Pollock. I did interview Mr. Pollock, but unfortunately our schedules were such that I had to do it over the phone. I called him and spoke to him over the phone.
Right, but I mean, you listened to a bunch of other statements, audio statements by witnesses, right?
Oh, absolutely.
And you read their written statements, right?
Yes.
Nobody other than the defendant had a first-hand account from start to finish, did they?
Well, no. There was only one person there that's unfortunately still here with us that can do that.
And are you aware that it was actually 2 minutes between the time he hung up with the dispatcher and the time that Trayvon Martin's phone went dead? Were you aware of that fact?
Let me object, Your Honor. That would be a mischaracterization of the evidence, though he's allowed.
Okay, rephrase your question.
Do you know what time Trayvon Martin's phone went dead?
Can you explain to me what you mean by went dead, sir?
Yeah, when it cut off. Did you see the phone records in the case?
Yeah. Are you referring to when the call ended?
That's right. Did you see that?
I believe I don't. The phone records from Trayvon Martin's phone. That one I can't. I think I saw them, but I don't know that I saw that particular variable in there. I don't want to say that I saw something that I didn't see.
Well, you thought you were provided everything, right?
Yes, sir.
Okay. Do you know whether or not you were provided Trayvon Martin's cell phone records?
There were cell phone records there. Again, I did not. The cell phone itself, to me, when I was doing my evaluation, the actual cell phone, I didn't see the weight that it had when evaluating the actual use of force event. So the timeline that you're relating to me, I can't speak directly to.
All right. Did you have the testimony of a woman named Rachel Gentile?
Rachel Gentile.
Young girl from Miami was on the phone with Trayvon Martin.
Your Honor, just not to interrupt, but I don't know if you would know her by that name. So,
Well,
Well, to the extent that that's an objection, overruled.
okay. Well, I'll rephrase it.
Yes, sir.
Did you hear the testimony of the woman who claimed to have been on the phone?
Yes, sir.
With Trayvon Martin? And did you hear her say in her testimony that the phone went dead shortly after, or right after she heard a bump when she was talking to Trayvon Martin?
Yes, sir.
Okay. In creating your timeline, you said timelines are important, right?
Yes, sir.
Did you put together that it was 2 minutes from the time the defendant hung up with the dispatcher and the time that Trayvon Martin's phone went dead?
Using those timelines and evaluating on the timelines, there's a lot of questions that timeline creates, and being able to compare when the dispatcher's phone went, because I can't comment on how they were geo-synced or GPSed or anything like that for the accuracy of the times both by the provider and dispatch. But there's a lot of things that even Ms. Gentile said were taking place during that time that don't seem to line up either. So I want to be very cautious about how I just restrict myself to your timeline for that 2 minutes when there's other variables that if they played out the way that it was elicited from her would have a different outcome. So I just want to be very cautious in how I answer you with that.
All right. Well, I'm not asking you to be cautious or the opposite. I'm just asking you, did you take note of the fact that there was a 2-minute gap between the end of each of those calls?
I did not give that weight. No, sir.
All right. And in your conversation with the defendant, he described this whole event to you, right?
Yes, sir.
Okay, but you didn't have him mark on a diagram where he claimed, or an aerial photograph where he claimed the confrontation began?
No, sir.
And you didn't have him mark how it progressed from where he claimed it started to where it ended?
I didn't require Mr. Zimmerman to create any kind of drawings or mark on any kind of pictures or anything.
And the defendant did not describe for you from what direction he claimed that Trayvon Martin approached him?
I don't as far as the direction, that would have been my failure not to ask. He said he was approached, and I didn't specifically ask, was it, if you mean by direction, north, south, east, west, that would have been my failure not to ask that.
Okay, well, I'm not talking about geography. I'm talking about front, back, side.
I got the impression he approached him from the front. During our conversation, it was pretty clear that he approached him from the front.
You didn't ask the defendant what hand Trayvon Martin used to punch him, right?
No, sir.
You didn't ask him how long it was between the time he got punched, as he claims, and the time he went to the ground?
I didn't ask him for specific times, and again, I reference back to what I already said, that when I interview somebody for a force event, or if I review a force event, time is so fluid. Actually sitting there saying, well, was it 5 seconds, was it 10 seconds? There's a period of time that took place. It's fluid, it's movement, it's evolving, so the presumption that once it begins, their concept of time becomes less relevant, so I don't lock anyone into a specific timeline in that regard.
I know, but the timeline is important to you, right?
The overall timeline, yes, sir.
Okay, and the defendant didn't describe for you how it was they moved from where he claimed the confrontation started to where they ended up?
No. There was no explanation as far as how they transitioned from that.
That fact doesn't speak to you about the level of the confrontation?
Well, understanding the dynamics of a combat event or a fight, there's a lot of things that spoke to me about what he said and the other witnesses said in this case. And when you evaluate it and look at it and how did you get from here to here? How did you end up on your back? Why weren't you on top? The evolution of the event itself and the imperative part that becomes down is when the actual physical confrontation began and when it intensified. Where they transitioned, being in combat events myself, being in fights and knowing that they start here and end up over here, well, how'd you get there? We were tussling, we were struggling. Oh, I apologize. We were involved in this person-to-person conflict. How they transitioned from one spot to the other spot, given there was no major event that took place at that point, I didn't try to narrow them down on a time for that.
Okay, but I mean, you didn't ask him, not just time, you didn't ask him how they got there, right? What happened in between?
The fight started here and ended up on the ground there.
Right.
And I did not inquire from him specifically how he got from this point to this point.
Right,
No,
as in whether or not they were rolling over there or whether or not they were fighting standing up over there to get over there, right?
Right. I would presume, based on the physical evidence, I wouldn't even presume they were rolling over there. But, whatever the struggle took place, I personally didn't inquire about that, no, sir.
Okay. And you were asked by the defense counsel if you took into account the placement of the defendants, I think it was a key fob with a flashlight on it?
Yes, sir.
Isn't it true you didn't ask the defendant about his losing personal property throughout this event, where and when he lost things?
I don't recall. I can't say honestly whether I asked him that directly or not. I don't think I did, but I don't recall specifically, I'll be honest.
You didn't ask him how he lost his keys or the little flashlight, did you?
No, because as far as that point, with the way you phrase it like that, I don't know what you're asking me there. I didn't ask him specifically how you lost your keys. I didn't ask him how he lost his keys.
Were dropped, right?
Well, I saw the photograph and evidence also that there was a picture with that item right there, right by the sidewalk on the grass.
Did you ask him how he lost this? And for the record, it states 145?
No, sir.
Okay. This, by the way, would that be an impact weapon?
May I hold it? I wouldn't know
Sure.
what's it made out of, how much of the way. I mean, anything can be an impact weapon. Sure. Yes, you could use this to strike somebody.
I mean,
Absolutely.
so when you were testifying earlier about your familiarity with impact weapons, that would be one.
This most certainly could be used in that form or fashion. Sure.
And the defendant told you that his head was repeatedly slammed into concrete?
His words were, excuse me, his words were his head was slammed into the concrete.
Okay. You didn't ask him how many times?
No, not how many times it happened. Again, we go back to perceptual distortions.
All right. And you didn't ask him how his head was slammed, right? I mean, whether Trayvon Martin grabbed his ears or grabbed his face or grabbed his jacket?
No, I didn't ask him specifically how his head was being impacted into the concrete. I, again, generalized statements from Mr. Zimmerman himself because he doesn't account for the overall weight of my opinions. And there are many ways, but the way he related the information, despite there being many ways for his head to contact the concrete, the manner in which he related the information about being struck in the face and his head striking the concrete, it could have been during the strikes. But his perception was that the downward blows, his head hitting the concrete, his head was being slammed in the concrete. And I even got that from the video that you recommended I watch.
His video, right? The one?
No, sir. The one you mentioned about Hannity.
Right.
Sean.
Right.
Yes.
He said it that too, right? Didn't he?
Yes, sir. And if the verbiage that I looked at there also, again, perceptual distortions is he's being struck in the face and his head striking the concrete. We can put weight to various things, and, as an expert, each and every one of these things in and of themselves may not account for everything. It's the totality of everything. And what caused his head to hit the strike or to strike the concrete? It's clear that his head was in contact with a hard surface based on the injuries on the back of his head. The striking of the face, could that have been what caused him hitting the concrete? Sure. Was he being pushed down? Another option is, if we think about Mr. Good's statement, because Mr. Good's statement adjusted from when he initially gave his statement, if it was not always striking but pushing, if Mr. Zimmerman's trying to rise as he shoved back, even if it was a pushing down motion, could that result in his head striking the concrete? Absolutely. Regardless, from my perspective as an expert looking at it, there's a variety of ways in which his head could have impacted the concrete, but it's clear that he was struck and his head did make contact with the hard surface.
Right. And I think you said you reviewed some medical records?
Yes, sir.
Okay. Did you review the medical record that where the woman measured the longest laceration on the back of his head is 2 centimeters?
I don't want to quote the distance, but yes, there was they weren't that large. Is that what you're asking?
Right. Well, 2 centimeters, right? That's less than an inch.
Okay, I'm really not good with that. I got to be honest with you. If 2 centimeters, I'll say yes, but if that's less than an inch, I really.
You remember the length of the other one? Half a centimeter? Does that sound right?
One up until that. Okay, yes, sir.
You didn't ask the defendant about whether any blood from his nose got into his eyes or his mouth, did you?
Well, I didn't need to ask about the blood getting into his eyes because at the time the photographs were taken, they seemed pretty fresh and there was no blood all around his face. And as far as in his mouth, I didn't ask that, no, sir.
And you didn't ask the defendant whether or not he tried to cover his face while this was going on, did you?
No, sir. I just merely asked him to tell me what took place.
And you didn't ask the defendant whether or not he tried to strike Trayvon Martin?
Well, I didn't spend a lot of time asking him a lot of things.
The defendant never told you, did he, what he was doing with his hands while this was going on?
No, sir. I don't recall him saying anything.
You talked about vantage point.
Yes, sir.
You'd agree with me that out of all the people you heard from, either talked to or had written statements or audio statements, the person with the best vantage point would have been the defendant, right?
Of course. He was there through the entire thing, and he was an active participant.
And you would agree that if Trayvon Martin had lived, his vantage point would be important too?
Sure, absolutely.
The defendant told you in his statement that Trayvon Martin was straddling him, right?
Yes, sir.
And you understood that from the context of your conversation that Trayvon Martin was over the defendant's belly button, right?
It was over his waist area.
Well, didn't you say previously over his belly button?
During our conversation that we had in deposition, and I was actually not provided with a transcript, so I'm just going off memory here. I believe we discussed it and we identified it could be the waist. I mentioned that a high mount, it can be over the waist, the belly button area, but we also discussed it and I mentioned that it could be down around the waist, upper thigh area.
Would it refresh your recollection to see a transcript of your deposition since you haven't had one to refresh yourself on what term you used?
Sure.
By area of belly button, you mean here?
No, I object that he needs to read the entire question.
You can do that on your redirect.
Okay.
By area of belly button, do you mean here?
If that's where your navel is, yes, sir. The area is, it's either going to be below that, it's going to be in the area. I wasn't trying to say that it's on his belly button.
You recognize this as being a human-type figure, right?
Yes, sir.
Okay. It's actually got a belly button, right?
It surely does.
Does it appear to be anatomically correct?
For the belly button, yes, sir.
All right. So, as the defendant described it to you, is this the way he described it in the area of his belly button?
Well, what's really important right now, sir, number one, you've got your knees up pretty high on his waist. If you want to slide down just a little bit more so that you're in the air, there you go. Have a squat. I can't see your crotch, but in the area of his belly button, yes,
Okay,
sir.
well, here's his belly button. Am I in the area?
Yes, sir.
Okay. By the way, did you have the defendant do this?
No, sir.
When you talked to him, you didn't have him do that?
No, sir.
Okay. If this person, this mannequin, were carrying a firearm on their waist, where would the gun be right now in relation to me?
Would be at your left inner thigh.
Right here, right?
Yes. If he was right-handed, it would be at your left inner thigh. Yes, sir.
Right. Underneath my leg.
Yes, inside your leg.
Okay. Were you aware that the defendant described to his best friend that when he slid down, the defendant slid down, that Trayvon Martin was up around his armpits? Were you aware of that?
No, I've not heard that. No, sir.
Okay, well, where would the gun be now?
Now the gun would be behind your left leg.
Okay. The defendant did tell you, though, as well, that at some point he slid down further between Trayvon Martin's legs.
Yes, he did indicate that he was sliding down, and I believe that's how the jacket came up, exposing the firearm.
You know, if I can have just a moment. You didn't ask the defendant how he was able to get his firearm, did you?
No, sir. He explained that he reached down and grabbed it.
But he also explained that Trayvon Martin was in the area of his belly button, right?
Yes, at one point.
Right.
The whole thing's fluid, so it's not like Trayvon
Right.
just got in one spot. He moved all around, and
He
it
said
didn't
at
move.
first he was in the area of his belly button, and then he actually slid down. That happened after, right?
Yes.
And then he said that's when he grabbed his gun.
Yes, after he had slid down, the jacket came up. You're implying that Trayvon didn't move so that it wouldn't be accessible, but we have to remember in a dynamic event, it's not just one person doing all the movements, so we have to take into account both sides of the equation as it's interacting.
Well, did the defendant tell you that Trayvon Martin slid down? He didn't do that, did he?
No, sir.
You were asked if you reviewed the medical examiner's report.
Yes, sir.
You did?
Yes, sir.
Do you remember the trajectory of the bullet being referenced in there at being at 90 degrees?
Yes, sir, and I believe front to back.
Right. Wouldn't that be consistent with Trayvon Martin getting off of George Zimmerman and George Zimmerman raising the gun and firing it?
Well, when you talk about angles of anything, sir, it could be consistent with any kind of movement. We could say it could happen that way, it could happen another way. There are various ways that you could have it happen, and you weren't there, I wasn't there, so the information that we have is what
From the
Mr.
defendant, right?
That's correct, sir.
Okay. Judge Malcolm,
Yes, he may.
I mean, your information came from the defendant.
Not all of it, sir. Your
Well-
indication is that the only person I spoke with is the defendant, and that's not accurate.
I'm talking at the time the shot was fired.
The time the shot was fired, the information that I culminated on opinion on that is a culmination of everything. The only person that could provide any insight into at that very second that was there was Mr. Zimmerman.
Okay. And he said he was in the waist area, and then the defendant may have, or Trayvon Martin may have slid down. And my question to you is, would it be consistent, the 90 degrees, if Trayvon Martin had been backing up and the defendant raised his gun and shot at 90 degrees?
With you at that angle, 90 degrees to what, sir? When you talk about 90 degrees, we're talking about
Right.
this degree.
Right.
So if it's front to back 90 degrees and you're standing there and you're holding the gun up, already you're at least 45 degrees where you are because he's laying flat on the ground.
Right, but if
and you're
Trayvon
standing
Martin,
straight up.
if Trayvon,
One at a time and slow down. Just a little
I
bit.
apologize. If Trayvon Martin's backing up, could not the defendant have shot him at a 90-degree angle?
If Trayvon Martin is backing up,
Correct.
and you're saying that Mr. Zimmerman is laying on his back, and he brings the gun to bear on Trayvon, and if he's backing up, then now suddenly that bullet's going to go straight in, back, front to back.
I'm
at
asking you,
90
could
degrees.
he shoot him at a 90-degree angle?
I think I'm getting really lost in this 90-degree thing is really, I don't want to misinform the jury with my answer.
Okay. Well, 90 degrees was what you read in the medical examiner's report,
That's
right?
correct. And my interpretation was 90 degrees front to back was like it was a for lack of a better word, I'm not a medical examiner, but my interpretation of the information provided was that it would give it a front to back, for lack of layman's terms, like a level entry, not an angled entry.
Correct.
So as this event is transitioning and you're coming back, if this comes back, then we maintain that.
Right.
If it's a struggle that's forward, so in your 90-degree reference, I want to be very clear that I'm not trying to say that the manner in which you're demonstrating visually right there, with him raising his gun up and you sitting back, I don't know how you could get a 90-degree entry if you're sitting straight back like this.
Well, I'm not sitting straight back. I'm just...
From my perspective is all I'm trying to say, sir, is
Okay.
it looks like you're more vertically upright and he's sort of like the two of you form a 90.
Right.
And if the two of you form a 90 where you're straight up and he brings the gun to bear just based on the dynamics of his arm, there wouldn't be a way for it to go straight in. There has to be mutual movement to keep them within line.
As in, if the defendant started to sit up and Trayvon Martin was getting up, are you saying that there couldn't be a 90-degree angle?
Am I saying there couldn't be a
Right.
90-degree angle with
Right.
him in a half-up position
Right.
and you trying to get up? If the bodies become in line, it's as long in order, for my understanding, to maintain the entry, we're going to have to maintain some relativity between the two persons, right? So the relativity, I can sit here and say the same thing, that if I'm laying completely back and you're more forward, I can get a 90-degree entry. If we're both coming up, you're asking me to bring up a conclusion, could it happen that way? The answer is absolutely yes. If he's getting up and he's getting up together, sure. There's no way I can sit here and say that, no, you couldn't have two people that are maintaining alignment not have that entry.
And you were also provided the firearms report, right? And you learned that it was a contact wound with the clothing that Trayvon Martin had on?
Yes, sir, the clothing.
But it wasn't a contact wound with his chest.
Correct.
So that would be consistent with Trayvon Martin leaning over when he got shot.
Yes, sir, sure.
Okay. You were asked, or you actually spoke a little bit about the lighting, right?
Yes, sir.
Did you, you actually went to the scene for the purpose of getting idea of the lighting, right?
Yes, sir.
But you didn't get an idea of the lighting, did you?
No, I failed to go take into account the change in season. So when I got there, it was still daylight or dusk area.
And when was that?
Off the top of my head, I can't remember the exact date, sir. I think I might have told you in deposition, but I don't remember exactly off the
Could you
top of my head.
ballpark it? Was it in July?
July? No.
Was it in June?
Maybe early June. I don't remember the exact date in which I attempted that.
So you went to the scene to try to get an idea of the lighting, and
Yes,
the
sir.
sun had not gone down.
Correct. It was not completely set.
Right. So you didn't wait until it had set,
No, sir.
and you didn't go back
No.
when it was dark some other day.
No.
The defendant told you that Trayvon Martin reached across his body to try to get the gun,
He mentioned that. Yes, sir.
but he never told you that Trayvon Martin actually touched the gun.
I don't believe he said he actually touched the gun. He felt him moving toward the gun. He perceived that he was moving toward the gun.
Were you aware that the defendant told his best friend that Trayvon Martin actually touched the gun, grabbed it?
It's possible he said that.
I mean, did you don't?
I don't think it would affect, whether you're reaching for it or grabbing it.
I'm just
Six
asking.
one half of that's in the other.
Mark Osterman, does that name sound familiar?
Yes, sir.
Did you review his testimony or his statements, pretrial statements?
I reviewed his statements, but I focused in on the people that actually had witness accounts. Again, my job as an expert is to look at the event, not hearsay that comes from somebody else that they're saying, because number one, dealing with man to man, I have always got a concern that I haven't met too many men whose egos don't enter into it when they're having a conversation with somebody. It's usually generally women that can keep their composure and not feel like they're, have to say something that makes another guy feel better about them. But the statements I focused in on were the events that took place there, not 110% what somebody else said they heard somebody say.
But part of your focus, a good part of your focus, was the only witness who could tell you from start to finish, and that was the defendant, right?
No, the totality of the event. Again, you're trying to narrow it down, and it's interesting because we could narrow it down to any specific part that you'd like, not just the one part that seems to be advantageous. When we look at the totality of the event, I reviewed everything from everybody that can provide information about the event itself. It is true, the only person currently that we can gain information from that specifically can address the event that unfolded away from the calls and away from the one person is Mr. Zimmerman. Not Mr. Osterman or anybody else, just Mr. Zimmerman.
Was your conversation with the defendant important?
Of course it's important, sir.
So wouldn't his statements to someone else about the exact same event also be important?
Sir, I've listened to the statements related by other people, and it always comes back down to the fishing story, that even though somebody may want to be supportive, the human element, the human mind, likes to fill in the blanks. It's a natural human thing that we see something, and if we don't understand it, the creative side of our brains will help us fill it in. They will find a way. And that is another reason why if you wait too long and you allow people to get too many interactions with other people, the statements can change because now they have outside influences. As far as what he said to somebody else, bringing in as adding more importance to me at that point, that would be inaccurate because the information I need is about that night, not somebody else's interpretation about what somebody else said.
And you talked about the use of force continuum, right?
Yes, sir.
And explain that for the jury what that is.
Like I said, it's a force continuum. It's a systematic approach to escalation and de-escalation of force, taking into consideration background training experience, weapons availability, and the totality of an event. It's basically saying that if X happens, you can respond with Y. It's right. The idea is to give an objectively reasonable connection between two behaviors.
And if Trayvon Martin was backing up, as I demonstrated a moment ago, that would be a de-escalation of force, right?
Sure. If a person is disengaging, it would be a de-escalation. Right. As long as they're not disengaging to go to another weapon, but right. Just in general terms, like you mentioned, of backing away, if I was giving up, that's a de-escalation.
You also mentioned in the force continuum there are options, right?
Yes, sir.
Okay. And you would agree with me that someone in the defendant's position had other options?
I would disagree with you, sir. You're telling me that somebody in the defendant's position, the moment that perception became a deadly force encounter, the only option that's justifiable would be the actual application of that level of force. We can sit here all day long and come up with 1,000 things that may have been able to be done, but the reality comes back to what a person is perceiving to be their reality and what the approved responses are for that given reality.
Okay, but you don't know what was in his head, do you?
Based solely on the information that I reviewed, based on what I heard from the 911 calls, based on the inclusion of the physical evidence of the injuries to his face and the back of his head, and the fact that, in my opinion, most of that information meshes together. So I can draw my opinion and I can come to the conclusion of what I believe the perception to be. And based on that perception, I know what a generalized outcome could or should be.
All right, when you said 911 call, you talking about the one with the screams on it?
Yes, sir.
Okay, you're not telling this jury that George Zimmerman's the one screaming, are you?
I'm not telling the jury anything other than what I just told you. If you take into consideration the 911 call, you mentioned whether it was him or not. I wasn't there. I couldn't tell you that. I can tell you that based on Mr. Good's statements, that he believed that the screams for help were coming from the gentleman on the bottom. Otherwise, he would have heard an echoing sound because it wasn't facing away from him. And if you take that concept and you include it in, then it would fall into play that those screams were Mr. Zimmerman. But in the same token, if you're on top trying to hold somebody down to disengage, as you've indicated, I'm trying to get away from him, and somebody now is coming out saying, hey, stop, and there's no indication from you as the person on top trying to hold somebody back that you need help, and that your inference is that those screams were his help, why was there no acknowledgement of the person behind him? So again, any one of these things in and of themselves don't tell the whole story. It's about taking all of the information and considering all of the components and coming to a conclusion.
Let me ask you this. In your experience, if Trayvon Martin or anyone would have been in that situation and would have been aware of the defendant's gun, either seen it or felt it, would you expect them to scream for help?
You're asking me if somebody saw, if I am beating the crud out of you and I suddenly know you have a gun, would I expect me to be screaming for help?
Would that be unusual for a person who saw a gun too?
You just said if I was Trayvon Martin in that situation and we take it to the place that we've gone with the physical evidence where I'm the aggressor, I'm on you and suddenly I see you have a gun, my first instinct as the aggressor is not going to be to scream for help. My first instinct as the aggressor, if I'm the one that's being the aggressor, is to go for the weapon that's going to help me continue my aggression, not prevent it from being implemented to stop me.
Okay, my question was, it would be unusual for a person who saw someone that they were in combat with a firearm, would it be unusual for that person to yell for help, in your experience?
I want to make sure I'm clear, because you just said, would it be unusual for a person involved in a combat situation to suddenly see a gun and scream for help? Is that the question that you... I want to make sure I'm very clear on it, because I don't want to misinterpret this, because I want to be careful in what I say with what you're asking.
I'm trying to make it more simple. I mean, if a person sees a firearm, would it be unusual for them to yell for help?
If the average individual saw a gun and it was pointed at them, I would say absolutely not. Anybody looking down the barrel of a firearm, if you're able to vocalize something, would probably yell for help. I mean, if you're looking down the barrel of a gun, I would hope if you're looking down the barrel of a gun, you'd be in fear for your life.
All right, back to the options. We kind of got away from that. There are other options that George Zimmerman could have used to get out of that situation, right?
Based on my understanding of his physical skills and things, he wasn't physically trained. Asking of options, we go back to what we talk about for subject factors, variables involved in an individual in the event. What's your background training and experience? One of the training instructor certifications I have is in one-on-one control tactics, and that is a ground fighting discipline. So, yes, there's a lot of options that are available, but if I have no background training or experience to lead me down those paths, there's nothing else. So I am very limited on options. There are always options in every force event. It's just a matter of what you as an individual see as being your options.
Right, but the defendant didn't use any other options, did he, other than pulling out the gun?
Well, I mean, if we go down the path where he was the one vocalizing, he did scream for help, he elicited assistance from other people, there were other options. He obviously continued to try to resist. He was doing, as I guess they refer to as the shrimping technique, trying to get and move around. As far as drawing a conclusion, I don't know what else he could have done based on his abilities, because, not to be offensive to Mr. Zimmerman, there doesn't seem to have any.
You're not suggesting that the defendant was just laying there getting hit, right?
Absolutely not. No,
he would
sir.
have been defending himself.
I would presume that at a minimum he would be struggling in some form or fashion to create some kind of gap or distance. Instinctually, that seems like it would just be a normal thing.
Did you say that there's a verbal component to the use of force?
Absolutely.
Like telling someone who you are?
Well, the verbal component is anytime you interact with people, you can escalate or de-escalate an issue based on communication. If the levels that, when we speak about law enforcement, you have presence, and they offer different levels of resistance. For us, it would be, you tell them, stand over here. No, I'm not doing that. Well, that's verbal resistance. That's a verbal communication. The officer's response can be verbal, which would be, you're under arrest, come stand over here, blah, blah, blah. In the individual or civilian realm, verbalization can be screaming for help. It can be telling the person, no, stop, don't, whatever those cases might be. That's the verbal component.
And it also could be like telling them who you are. Like, I'm a resident here. I'm a neighborhood watch person.
Absolutely. You could tell them that I'm Dennis Root and I'm here to say hello.
And you could tell them what your purpose is, right? Like, I'm a neighborhood watch person, and I'd like to know what you're doing.
Yes, yeah. If you afforded the ability to communicate with somebody, it's always a good idea to introduce yourself and advise them about it.
You would do that before using force, right?
Well, sir, again, you're asking me what I would do, and I can tell you this. There's a lot of things that if I was in that same situation, I most certainly would have done differently. But the reality still comes down to when you say that somebody that's based on, again, going off 911 calls, this gap, whatever it happens to be, he's in an environment, he's doing what, the golden rule of community-oriented type programs is if you see something, say something. That's the whole idea. And Mr. Zimmerman has a history of that. He reported, by the calls, everything. He's had numerous calls from a variety of reasons, from children to suspicious persons. The interaction component, is he responsible for when you walk up to somebody and if they're in a suspicious area, hey, I'm a crime watch person, if you have the distance and ability and that comes to mind, that's fine. But that also takes training and thought on the forefront. However, on the other side of that coin, if I'm suddenly surprised by something, communication may not be the first thing that comes to my mind, especially if it's a blind side of some type.
You did talk to Adam Pollack, right?
I did, sir.
And you actually talked to the defendant about some of those classes, right?
Yes, sir.
But you didn't ask the defendant how long he had been taking those classes?
No, sir.
And you would agree with me that should have been asked?
No, sir.
Did you not say that not getting that information was a failure on your part?
Yes, and as I would say anything, just like I did about asking the other thing, anything I don't ask, I always take on as my responsibility. It doesn't change the outcome of an event. It doesn't change the total influence. The fact remains that if he had been spending 3 years and was just barely able to get into a grappling ring with somebody where he can say uncle, and he spent 3 years boxing and he can't even get a ring with another person, it really is a moot point about how long he's been doing it. The end result is I got the information from the source that actually can give me a neutral opinion because he was the one doing the training.
Because the defendant's not neutral?
Sir, just like we said, and you said it yourself, you have to take it with a grain of salt. The only way that I can come up to a neutral opinion on anything is by giving minimal weight to Mr. Zimmerman and trying to find the information from some other source. Unfortunately, depending on the variable that we're asking, the only source may be Mr. Zimmerman, but sources that I can get information from somewhere else other than the defendant, I would seek that because that gives me more possibility of getting the truth rather than what some quote-unquote defendant wants me to hear.
All right, so you didn't ask him for how long he had been taking the classes, like over a year. You didn't ask him?
No, sir.
You didn't ask him how long each class was, like 2 hours?
Generally speaking, when you look at any of the combative sports, you're looking at an hour and a half to 2 hours because of warm-up, stretching, the actual activities, cool down, and stretching again. So I probably didn't ask that only because the general guidance on that for just physical technique-type classes, that seems to be the norm.
And you talked a little bit about Trayvon Martin. You wanted to know about his physical ability, right?
I would love to have known totally about it, yes, sir.
But you said, I believe your words were he was physically active.
That was my understanding, yes, sir.
Because you had information that in middle school he played football.
Again, and I believe I even said it, before this case began, there was information in the media.
Your Honor, we approach for a moment?
Yes.
Sir, I believe you testified on direct that you were told that he played football in middle school. Is that right?
Yes, yes, sir.
And you had his height and weight, correct?
Yes, sir.
5'11" and 158 pounds.
Yes, sir.
You got that from the autopsy report?
Yes, sir.
Judge, if I can have just a moment.
Yes, you may.
You were asked questions about basic certifications for various weapons, right?
Yes, sir.
And you're aware that the defendant had a concealed weapons permit?
Yes, sir.
So he would have taken a course for that?
Yes, sir.
Isn't a person who is licensed to carry a concealed firearm supposed to disclose that to the police when they talk to him?
There's no law about it.
Aren't they advised to do that? When you speak to law enforcement, you advise them that you're armed?
You mean in person?
I mean, over the phone, in person, at all?
Not over the phone. Whenever you interact with a police officer, if you're carrying a concealed weapon, obviously, traffic stop, interaction on the street, something to that effect, we tell everyone that when you interact with law enforcement, the first thing you want to do is make sure your hands are clearly visible and just let them know that you have a concealed weapons permit and you are carrying a firearm. We don't really ever address something over the phone. I mean, sure, I guess it would be nice, but...
You said, well, to be clear, the defendant did not advise the dispatcher that he was carrying a firearm.
No.
And you said that you have a criminal justice degree, correct?
Yes, sir.
Were you taught the law of self-defense in any of those courses?
I've taught a lot of laws, yes, sir. I'm sure we covered that.
Were you taught fact scenarios that constituted self-defense?
I can't say that we are fact scenarios. Every instructor that's responsible for relating information relates it differently in every class. I can't speak to how everybody does it. I know how I relate the information, but I can't speak to how everybody else does.
And it was your opinion that a weapon was not used on the defendant?
I didn't see. Are you talking about Mr. Zimmerman? There was no weapon used on Mr. Zimmerman by Mr. Martin?
I believe that's what you said.
Yes. I didn't see any indication that a weapon of any type was used on him.
You did see an indication that a weapon was used on Trayvon Martin?
Did I see?
Did you see an indication that a weapon was used on Trayvon Martin?
He was shot, yes, sir.
You know, if I have just a moment.
Yes, you may.
Mr. Root, in listening to the non-emergency call and your conversation with the defendant, he told you he was following Trayvon Martin.
I think the term that he used was trailing, which to me, it means following. I mean, it's the same thing.
Okay. I mean, do you remember when Sean Nofke, the dispatcher, asked him, are you following him? And the defendant said,
oh, yes, sir. Absolutely. In the 911 call, absolutely. He asked him, are you following him? He said, we don't need you to do that.
Did you read the defendant's written statement?
I'm sure I would have.
It was about
recall.
4 pages handwritten.
I am confident I did. I just don't recall exactly what he had written. I mean, if you ask me a question about it, if I don't know, I'll honestly tell you. I've read so many of the documents.
I understand. Do you recall the term that the defendant used to refer to Trayvon Martin in that written statement?
No, that I don't recall the term that...
You don't recall the term suspect?
Okay. I don't directly recall it, but I would take your word that he wrote suspect there.
You would agree with me that that's a police term, right?
Oh, sure. It's a term that it's also a crime prevention term also. It's anybody that you interact with, they utilize the same verbiage, even though he may not get it. Most certainly, it's like saying civilian, and I get yelled at by a friend of mine because it's individual. But in law enforcement term, every individual is a civilian. So for suspect, we refer to as being the other person, the bad guy.
All right. Judge, that's all I have. Thank you.
Yes, Your Honor. So I'm clear, would you consider a big old piece of concrete a weapon if I hit you on the head with it?
If you hit me in the head with concrete, yes, I would.
How about if I
consider
just
that.
took your head and smashed it onto concrete? May I use your doll for a moment? Of course. Let's just use this for a moment because I want to follow up on some of Mr. Guy's questions. So, George Zimmerman, Trayvon Martin. Were the injuries on Mr. Zimmerman's back of his head consistent with someone doing this on cement?
I don't think so.
How about this? How about somebody resisting the attempt? The injuries, the two lacerations, could that have come from cement? If somebody was resisting me pushing down like this?
I believe so. I believe it was a culmination of downward force, whether it was from pushing or striking, and I know clearly by the injuries to his face, and that would drive him back, his head striking hard into the concrete.
Would you expect, based upon your training experience, that somebody getting their head struck on the cement would attempt to resist it happening?
Of course, they would. Normal human instinct would try to move away from the pain stimulus, which would just create another gap to be driven back.
And would that occur not only the first time, but every subsequent time?
Whether it's a push or a strike, every time you drive a strike or push straight downward, the body goes until it hits an object that'll stop it.
Did you see the pictures of the injuries that showed punctate bruising and lacerations on the side of Mrs. Zimmerman's head?
Those were when I said blows raining down earlier, those were the things that really caught my eye, that supported the fact that it was a striking and not a pushing so much, because of all of the, lack of a better word, injury or damage that I saw on the side of the head. There's swelling all around his head. It's not just the facial area, it's all around the front.
Were those injuries consistent with somebody pushing a head down to the side? You see me move it to the side like that. Is that similar to that hitting cement?
It could be. It could be that, or it could be punches as well, driving those strikes in. And
then on the other side, were the injuries consistent hitting it down on the side, on the left side of Mr. Zimmerman?
It could be, and just like Mr. Guy pointed out, if Mr. Zimmerman is on the bottom and he's not just laying there, he is moving, whether he's trying to defend himself, trying to do his sliding techniques or whatever they are, as he's turning his body or his head in those efforts, it's going to redirect and realign, so whatever push or punch comes in next, if he's turned this way, it's going to be a strike to a side, the front. That's all indicative of an ongoing combat event.
Now, talking about the angle, Mr. Guy, I think, was suggesting that we need to stay focused with the angle of entry of the wound being basically 90 degrees, so it's straight in, correct?
That's what he said, yes.
Now, that could happen, of course, as Mr. Guy suggested, maybe something like this, if Mrs. Trayvon Martin is trying to now back away at the end of the 45 seconds of screaming, correct?
Correct.
Do you agree that that's a possibility?
Absolutely, it's a possibility.
Do you have any evidence that beyond a reasonable doubt that is what happened?
No.
Could it happen this way?
Yes.
Same angle. Could it happen this way?
Yes.
Could it happen if Mr. Martin is reaching back with his hand for yet the final strike or something like that? Could it happen right there when he's coming back over?
As long as the alignments of the body stay within those same relative positions, where they are within that axis of movement, it's a possibility.
Now, you know that Mr. Zimmerman was, in fact, able to get his gun out of the right side hip, correct?
Yes.
Now, somehow he got to that, correct?
Correct.
How much weight do you give to Mr. Zimmerman's ability to disclose and to advise exactly how that happened?
Not a lot.
Why not?
Because when he became aware of the presence of the firearm, he reached for it. The transition under stress, the transition of how it got into the hand is kind of moot. And, my background training and experience, I've interviewed numerous police officers involved in shootings. And frequently I hear, I shot, well, when you draw, they're not clear on how they got into position. They just know they did it. Instinctually, survival mechanism, whatever it is, the point still remains, the gun was in his hand and he did in fact discharge it.
And he discharged it in a way that was in contact with billowing clothing that was 2 to 4 inches away from his chest, correct?
Correct, which, when we think about the movements, if he's moving with I think it was an Arizona iced tea in his jacket, the hoodie, transition leaning forward, if that body position's there, that T is going to keep it away as they transition back. If he's at some point leaning too far back or whatever, trying to get up, that T is going to be pushing the shirt the opposite direction because it's going with the motion too. At what point and where they were, I can't specifically say.
Okay. in the context of your training experiences, the way combat events and how they occur, is it possible that at some point Mr. Martin was in fact up here?
There's no question that it's possible, because during the event, when he says he's sliding down, I don't expect Mr. Martin to be able to match him move for move. Is it possible that at some point he was up on his chest? Yes.
Okay.
Then he slides
And
backwards.
is it possible that at some point he was here?
Sure.
And how about, is it possible that at some point during that dynamic altercation he was even this far down?
It's possible.
When he's this far down, just over the thighs, where is that hip holster? I'm not going to ask you to get up. Just tell me when to stop my finger as to where the hip holster is.
Stop.
Right here.
Yes, sir. Right at the
Available
hip
to
line.
Mr. Zimmerman at that point.
Yes, sir.
Is it available to him at this point?
Yes, sir.
How about up here?
Yes, sir.
What is at this point, where you say it's available, what is my tie pointing down towards? Can you
His
see
belly
that?
button.
My tie is pointing directly to the belly button?
Yes, sir.
Based upon your training experience, was there just how much thrashing or movement was happening in that dynamic event between these two men at that point?
I would have to say a lot.
Was that evidenced by the contusions and abrasions on Mrs. Zimmerman's head?
Yes, sir. I mean, the clothing, showing the contact, the wet spots on the clothing. I think that you're not going to be involved in an encounter like this without it being dynamic.
Speaking of weapons that are available, we had talked about mass approach the witness for a moment. Do you consider that this could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Could be a weapon?
Yes, sir.
Most anything that you want to be a weapon could be a weapon, correct?
Yes, sir. I do training classes on improvised weapon systems. Anything can be utilized. Depends on how it's used.
You certainly agree that fists can be weapons, right?
Most definitely.
And you saw evidence of injuries caused by the weapon of a fist, right?
Yes.
And the weapon of concrete?
Yes, his head striking the concrete, yes.
And just so we're clear, did you see any evidence of any injury on Trayvon Martin from your review of the autopsy that was consistent with him being hit by this?
I didn't see anything to that effect, no, sir.
Did you see any evidence of any injuries of Trayvon Martin being hit by anything?
I didn't note any injuries on Trayvon Martin, except for there was the one point on his hand.
How do you explain that fact to this jury? How do you explain the fact that in an ongoing altercation, I'm going to presume for the point of this conversation that it was Mr. Zimmerman screaming, just for this.
Yes, sir.
And it was Mr. Zimmerman screaming for 40 seconds. How do you explain to this jury that he couldn't even land a strike in defense of himself?
Well, if you...
Is that object to that's called for speculation?
Your Honor, I would ask.
You're asking for an explanation?
I am, and the door has, I think, been open as to potentialities of what happened between the two that night by Mr.
I'll
Guy.
overrule.
Can you restate the question again? I'm
Sure.
sorry.
Can you explain to the jury a couple of facts? I'm going to suggest that it was Mrs. Zimmerman screaming, and you've now testified that Mrs. Zimmerman was not able to strike nary a blow on Mr. Martin. Can you explain to the jury how that might have happened, how that occurred?
Well, if we were saying that he's the individual screaming, then we could conclude that with Mr. Martin on top of him, Mr. Martin was the aggressor, the strikes were being rained down, and he, for lack of better words, was physically incapable of responding, screaming for help, wanting somebody else to help him out of a very bad situation. And it's possible that his hands were busy. They were, maybe they were pushing. I wasn't there, so I can't say exactly what his hands were doing. But I know that if you're the aggressor in a fight, how can you be the aggressor and not hurt somebody? So in this situation, if he's the one screaming, the reason that there's an absence of injuries is because he wasn't the one throwing strikes.
Is it unusual for someone to simply be completely dominated by another one who is physically better abilitied?
It all goes back to mindset, and it's not unusual, but what really, in listening to the non-emergency call that Mr. Zimmerman made, then it's clear during his conversation that he becomes concerned about Mr. Martin, especially when he's looking at him and walking back toward him, because he even vocalizes this to the dispatcher. He didn't get out of the car at that point to confront him. To me, my perspective is because Mr. Martin is not the I'm-in-your-face confrontational person. When he had the opportunity where he mentioned that Mr. Martin had taken off running, or I'm sorry, Mr. Zimmerman's not confrontational. When Mr. Martin had taken off, and he announced that he took off running, if that's when he gets out and he, is following, and the operator asks, "Are you following me?" He says, "Yes, I am." It's because there's no threat. He took off running. Everything about that one call that leads up indicates that he had concern about his safety. I can hear it in his voice. Then when he interacts with him and he's coming back and he's face-to-face with somebody, he's not confrontational. He's looking at me. He starts talking about and you can hear it in the voice that he's talking to the dispatcher. And then when Mr. Martin's leaving again, suddenly his vernaculars strengthen, and he struck me as the type of person that doesn't have a problem telling you that somebody's a jerk, but he doesn't want to tell them that. So I actually lost the question. I'm sorry.
That's okay.
I apologize. I know I was going somewhere. I just don't remember where it was.
I was just going to let you go, but we'll
Thanks.
refocus it. Let's start where I was going to.
Let me ask you a question. We have plans for the jury to go out for lunch, and it's going to take an extra long lunch time. Is this a good breaking point?
It is, Ron. Thank you.
Thank you. Ladies and gentlemen, as you're packing up your stuff, I'm going to remind you that you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the Internet to do an independent research about the case, people, places, things, or terminology. And finally, you're not to read or create any tweets, emails, text messages, or social networking pages about the case. I have your assurance that you'll abide by these instructions? Okay, with that, put your notepads down, follow Deputy Jarvis, enjoy your lunch. We'll be back at 1:45. Please be seated. Mr. Root, during the lunch hour, you're free to go about your own business, but you are not free to talk to anybody about your testimony. That includes the lawyers, okay? We'll see you back at 1:45. Is there anything we need to take up before we recess for lunch?
There are a few things that we have stipulations for entry, but I can do that at any point during my case.
Okay.
When we get back or afterwards.
That will work. Thank you. Court is in recess.